Hi, everybody. This is attorney Arkady Frekhtman. I'm a New York City personal injury trial attorney. And welcome to Last Week Tonight Live, where we answer your questions and we chat with you live. So thank you for being here. And let's see, I think we already have some questions. So let's get right into it. That's awesome. Yeah. So we have Mr. Hassan. He says, "Hello, dear attorney. If the injury person is not speaking good English, can he use an interpreter on the position or trial?" Yeah, absolutely. Absolutely. You can. You can use an interpreter. So it's pretty easy. You just have to ask your lawyer, and your lawyer has to tell the other side that you need an interpreter. And so the way it works is the party that does the questioning, they retain or hire the court reporter. That's the gentleman or lady who types everything and makes a book of all your testimony. And they also would have to hire and arrange for the interpreter. So you'll have the interpreter there. So yeah, it's fairly easy to do. Um, and then he has another question. If the lawyer referred me to the other lawyer because he is not licensed in that state, he will get paid because he referred me from that lawyer, or both will get paid? Well, that's hard to say. It depends on the rules, right? So if the lawyer is not licensed in a certain state and he referred you to another lawyer who is licensed in that state where you need a lawyer, the way it usually works is that lawyer, obviously, who's handling the case in the state where he's licensed and where the state where it happened, he'll get paid because he'll win you the settlement, and then his legal fee will be like 1/3, usually 33% or some percentage of what he wins for you. Now, the other lawyer, since he referred him the case, if he did work on the case as well, and if he participated in the case, and then it depends on each state's rules. But if the state's rules allow for it, then that lawyer, who's handling your case, can then send a small portion, like a referral fee or a co-counsel fee, to the first lawyer. So that's usually how that works. But each state has a different rule on that. Like in New York, we're allowed to do co-counsel fees, but I think some states are maybe more restrictive about that. Okay, and then Viral Guy says, "I've been waiting ever since deposition. Can you tell me what to expect, especially if I have a jury trial?" Yeah, well, I mean, that's kind of like a really big question, right? A jury trial is the end result. That's what you want. I was talking to somebody today and I was telling them, they said they don't want to go to a jury trial, right? Because they're just afraid. And I said, look, the best way to avoid going to a jury trial is to prepare for the jury trial. Because if you have everything prepared and you have all your experts on liability and you can prove the defendant was at fault, you have your engineers, safety experts, and you also have all your experts on damages, like your doctors, your economists, vocational rehabilitation experts, and you have all your subpoenas. That's when you're calling documents to the courthouse, like the medical records go to the courthouse, everything goes to the courthouse, everything is there in the subpoenaed records room. Well, now the insurance company's lawyers, they go there, they check that, and they see, hey, these guys aren't fooling around, these guys aren't bluffing, they mean business. They're really going to take this to trial. So at that point, the insurance company will say, you know what, let's lower our risk, because if these guys go to court, they could hit us for many millions of dollars. Maybe let's lower our risk. Well, how do we lower our risk? We have to offer them more money to settle the case, you see? So the best way to avoid going to trial is actually to prepare for trial. It's kind of like a little bit counterintuitive, but that's true. That's true. And in terms of what to expect, I mean, I would just say, make sure you prepare with your lawyer. I mean, what I do is I get my client's story, find out about them, their biography, how this particular accident, whether it's a car accident, trip and fall, construction accident, how it affected their life, right? How has their life changed? Who were they before this happened? And who are they now? And how is it different? That's the real key thing that you want to look at, because everyone's going to have medical records. Everyone's going to have some injections, surgeries. And of course, that's important. You have to have treatment. You have to have medical records. You have to have experts. But I think the differentiating factor is that human story. Like, who are you? What is your life about? What do you love as a person? Who do you love? Who's important to you? A lot of the common themes I see are things like, someone's injured. They don't want to be a burden on their family. They want to be who they were before. They want to be either the breadwinner, go back to work, make money, or, if it was a lady who was injured, she wants to do her role, take care of the kids, or, do the grocery shopping, or maybe the wife in the household, the lady, she goes to work and she makes a lot of money, but now she can't work, right? There's a lot of different possibilities, but the only way to really find out is to dive deep and find out about their life. And then, that's really important. So I would do that with your lawyer. Okay. And then Richard B says, hello, finally, the 26th is mediation day. I lost 10 years of work, pension, annuity, vacation, pension, tore long head in the left arm and neck problems. My lawyer has yet to say what this is worth. Right. So, yeah, that's good that you have a mediation. That's good. That means that the other side is considering, resolving the case and considering settling the case with you. So that's good. That's a good first step, but just don't get your hopes up. I want to be honest with you. I don't know how your lawyer got to the mediation, right? The way, like I've said it before in many videos, the way I do it is I make sure before I even agree to participate in a mediation, I make sure that the insurance company is going to give me a good faith offer. So, for example, if I want to get, if I'm trying to get $1 million, let's say, I got to make sure they're going to give me an offer for, let's say, 300,000. Now they're already, somewhere. So I'll say, okay, let's do a mediation. And at the mediation, we can just kind of like get closer to each other, right? I'm at $1 million, they're at 300, and maybe we could settle it for like, 700 or 600 or whatever. So it could be fruitful, right? But what often happens is people agree to go to a mediation thinking they're going to get millions and millions of dollars. Now the insurance company doesn't make any offer or makes a really low offer, like 10, 15,000. People show up to these mediations and then they just get disheartened because the insurance company uses the mediation as a place to kind of tell you how bad your case is and how they're never going to pay more than X. And then, the clients get upset, and then the clients get upset with their lawyer, right? And the whole thing just, doesn't really lead to much. So that's the critical factor. You got to make sure the insurance company is going to offer you a good faith offer at the mediation. But good luck. It doesn't mean they won't. It's just one of the caveats that you have to watch out for. Okay, and then Leonardo says, hello, hi, how are you? Great to see you. And Lost in Awareness says, how do you feel about an offer of judgment? My lawyer wants to send one because the other side is dragging their feet and he thinks it'll get them to be more proactive. My issue with the offer of judgment is that he wants to send 400,000 less than what we demanded, and I think it'll anchor us into that lower bracket. Oh, I see. So he wants to send them an offer of judgment and see if they'll take it. Well, he really shouldn't send less than what you're trying to get, because if they accept the offer of judgment, then you're going to get that, right? You're going to get that amount, and you don't want to take that amount if it's 400,000. That's a lot of money. 400,000 is almost $500,000 less than what you want. So I would just talk to him, come up with an amount you both agree on, because you're the client, right? Ultimately, it's your case. The lawyer is just supposed to be guiding you and counseling you. So don't let the lawyer, take the reins and try to get rid of the case for 400,000 less than you think it's worth. Come to an agreement on a number, and both of you give that number to the insurance company and to the defendants and see if they'll pay that. And then if they don't, and you get more than that, they could be liable for all the costs, right, and the attorney's fees. So that could be very powerful, the offer of judgment. Absolutely, that could be very powerful, and that could really be helpful for you. So that's a good, that's a good. It's not a bad tactic. It's kind of similar to what I do, because the way I do it is I do these settlement opportunity letters. So it's not really an offer of judgment, but maybe in some ways it's similar. What I do is I'll tell them, hey, the case is worth $1 million. Pay that. You have 30 days. Here's all the evidence. Like, I don't just say, hey, pay $1 million. I have to give them all the evidence, like the photos, videos, how the life has changed, medical records, like everything. Like basically, some people call it a settlement demand package or a settlement opportunity letter. I like to call it opportunity, like a window of opportunity, right? Because it's open for 30 days. So that's your window. Pay the $1 million. If you don't, that's fine. But now, after the 30 days is over, let's say we do it until, today's, March 7th, right? So we do it until April 7th. And so like April 7th at like 5 p.m., if you don't pay me by then, well, now it's not going to be $1 million anymore. It's going to be $2 million. And that's it. But you have to then stick to that. You can't start going back and say, oh, no, still take $1 million. You have to really stick to your guns, mean what you say, don't bluff, and be ready to go to trial. And have a record of trials that you've done, your lawyer has done, verdicts, big verdicts, settlements. See, then you're in the power position, and then you could kind of, as a lawyer, it's great, right? Because then you could tell your client, hey, this is what I think the case is worth. We're going to go for the $1 million because that's the entire policy by this date. But if they don't pay it, then it's going to be much more. It's going to be 2. And then by the time I have to pick a jury, it might be 4. And by the time I have to open up, do my opening statement, it might be 5, right? It just keeps going up. So then you could know what a case is worth, right? Because you base it on the file, conversations with the client, the medical records. You could do jury verdict reporters, right? Meaning other cases through all the different, research. What have other people gotten for this verdict? You could do focus groups, which are kind of like, jurors you could do focus groups in your county where your court is, and see what people there have to say about it, and whether people there believe that it's worth that amount, right, that you're going for. But see, the point is, you're in the position, you're going up, and you're in the position of power, because everyone else, the way they're doing it is they just start demanding really high. Like they'll demand $1 million. The insurance company will say, are you crazy? $1 million? How about we offer you like, 35,000? And then, what the insurance company wants to do is they want to take you and they want to drag you down into that $35,000, ballpark, kind of like that league. Then, it might settle for more. It might settle for 80 or even 125, but they're in that ballpark. You see, they'll never be, and you can never go up, right? So if you start at $1 million and you say, okay, fine, I understand you're only at 35, so I'll go down to 250. Well, now you've just gifted them 750, right? Because you're never going back to like, 650, 750, 850, $1 million. Forget it. That's gone. Now the most you could ever get is 250 because you can't come down, and that's what they want. They want to bring you down. So that's what I've said in other videos. That's why it's hard to say, like these lawyers, they can't tell you what your case is worth because they don't know how far these insurance companies and these decision makers that hold the purse strings, how far they're going to drag you down. Are they going to drag you down all the way to like, 50? Are they going to drag you down to 100? So you just got to be tough, and you got to be like, no, this is what it's worth. And you have to be, a trial attorney. That's critical, a trial attorney, because a trial attorney is someone who is going to be, sticking to their guns and saying, look, this is what it's worth. We're gonna go for it. We're gonna get it. And that's what it's all about. That's what I think is so critical, because you don't want to get dragged down. And insurance companies, that's what they're all about. They're all about saving their money. It's basically a business, like a corporation, a company that wants to make money. Unfortunately, they're not fair. And people get upset. People say, look, I got into an accident. It wasn't my fault. And I have these injuries. I had like a spinal fusion, an ACDF, or I had, knee surgery, arm surgery. How come they're not paying me? How come there's no settlement? How come they're not being fair? Well, because they're a for-profit business, right? That's why they're a billion-dollar, business, like whatever, Geico, Allstate, State Farm, Nationwide, whoever. That's why they have billions of dollars, because they take your premiums when it's time to pay. If you don't pay the premium, you get that letter at 12:01 a.m., right? Your policy is canceled. They're pretty good about that, but when it comes time to actually have a claim, do they want to pay? No, right? They want to use every trick in the book to try to either not pay nothing, or bring it down as low as possible and save their money. So it's just the way it is, unfortunately. Okay, let's see what other questions we have. Leonardo says, how are you? Always watching the live and all videos, learning. Oh, that's great. Yeah, that's awesome. Thank you for watching. Yeah, Leonardo's a great guy. He's always asking questions and texting me, and very smart man. And Truth Seeker says, good evening, Arkady. Did you get my email? And did you research anything on the Bradycardia. I want to be extremely careful on here just because social media is an open platform. Oh, I see. And a lot of defense attorneys. Yeah, I think I did get it. Yeah, I haven't had a chance to read it yet, but I will. I'll take a look and I'll do some research for you. Yeah, I'll take a look at that. I know what you're talking about. So I'll take a I won't talk about it, obviously because it's public, but I'll do a little research. Give me a few days. I'll try to get to it and I'll respond to you. And Hans says, is that a red flag if the lawyer refuses to tell me how much the case is worth after a year and a half with all my medical records and a lawsuit filed 5 months into the case and discovery coming in 4 weeks? I mean, I don't know. It depends on the lawyer. I mean, that's just one of the reasons, right? One of the reasons. I was just thinking about this myself. It's hard to say why another lawyer does or doesn't do something, right? Because you have to get inside their mind. But it could be a red flag. I mean, I've seen a lot of lawyers that just don't ever tell people what their case is worth. And there could be a few reasons. I think I did a video about that, right? All the reasons. But then I was just doing a consult with somebody on the weekend, actually. I was just chatting with this gentleman, and he was seriously hurt. And we were just chatting, and I was walking around. This was a few weeks ago. And as I was walking, it kind of hit me, and I was thinking, and I thought to myself, maybe that's the reason. Because he was telling me, like his case was kind of similar. It was like, I thought the case was worth, because he had like a TBI and multiple surgeries. I thought the case was worth like 5 million or 7 million. And he's telling me the lawyer, talked to me once or something. And the lawyer's telling me maybe they'll get me like 500,000, and don't want to tell me what it's worth. And I was like, why are they lowballing the case like that? And why are they not willing to tell him what it's worth? It could be because, they don't know how far the insurance company is going to drag them down, right? Because remember, the insurance company is like the elephant in the room, right? They're the ones who control everything, right? They hire the defense lawyer to defend and to litigate the case. They have the money, they have the policy as well as the umbrella excess policy. So they're the ones paying for everything. They're paying the defense lawyer whatever they charge, like $300 an hour to defend the case throughout the litigation, which could be like 3 years or whatever, 5 years. But they're also paying at the end, right? If you get a verdict of 5 million, that's what they're paying. So they're the ones that are really important. So if they're not, if they're going up against somebody who's like afraid of them, and all they have to do is save their money and drag that lawyer down as far as they can, right? Because that's what they want to do. They want to pay either nothing or as little as possible. So perhaps that's why I thought to myself that's why they're not telling you what it's worth, because they don't know how far the person with who holds the purse strings, the elephant in the room, the insurance company, the person with the power is going to drag this down. And that's why it's better to just negotiate from a position of strength. So yeah. But yeah, if you need a consultation, I mean, it's hard to say from one comment like that, but if you need a consultation, just text me 347-566-9595. I'm happy to chat with you, speak with you, and provide insight about that. And then Shania Chopra says, attorney, do all lawsuits plaintiffs have an IME? Yes, I mean, usually. I mean, not all of them, right? Because the case could settle before the IME. So the IME is called an independent medical exam. It's really not independent. It's really a defense medical exam. It's a doctor that's hired by the insurance company and the defense lawyer in the case. And the doctor is going to examine you for a few minutes and say that you're healthy, or that, if you're hurt, the injury didn't come from the car accident, it came from something else, like living your life, like the normal, painless aging process. It's nonsense. So anyway, yeah, I mean, it is a step in the process. The reason they have that is because, well, let's say you're hurt, right, in a car crash, for example. You could use your treating doctors, right? You could use doctors from the hospital. You might go to physical therapy, the surgeon who did your surgery. But who does the insurance company get to use, right? They don't have anybody. So they have to be able to, find somebody, this medical examiner, and examine you. But the whole idea is, if you're truly independent, then you don't have a stake in the race, right? If it's truly independent, it should be somebody that the plaintiff's attorney and the defense attorney agree on. And then that doctor, truly independent, could just examine the person and say, here are my findings. and then they could report it to the court, and then the court, but they don't do that. They just let them choose, and they choose these people that they always choose over and over again. And for whatever reason, a lot of the times they're choosing people that do not practice medicine anymore. They don't, they maybe they used to be at a hospital, but they're not anymore, because it's a lot of money to do these reports, right? To see somebody and to send a report like that to the insurance company. The insurance company will pay like $500 a pop. So why not just schedule the whole day? And like every 5-10 minutes, people, you see some of these places, they're crazy. You go to the waiting room, there's like double parked outside, people waiting to be seen for these medical exams. And these doctors are making so much money. And then to come and testify in court, they're charging from $5,000 to $7,000 a pop. And some of them have testified so much that, like, last time I was on trial, I had transcripts on the guy. The guy actually retired. He like moved to like another country, like it was in South America, but they flew him from South America for the trial, and he thought it was going to be like his last hurrah. But I actually had all his transcripts. It was so funny. I had transcripts like this, like this many transcripts, all the times he testified before, and every single time he said the accident didn't cause the injury. The person was not hurt. They're hurt because of something else, like living their life. So I kind of went through it with him. I'm like, you said it here, you said it here. And he was just like, yes, yes. He's just like, please leave me alone. Yes, whatever you say. And then we obviously won that case, and the jurors saw that this is just, what I like to call a jukebox witness, because, it's like how does a jukebox work, right? You go in, and you have a jukebox, and they can play a lot of different songs. So first you have to put the money in, and then once you put the money in, you can choose your song, and then the jukebox plays the song that you chose, right? But that's the same thing here. The insurance company puts the money in, they hire these doctors, they tell them the song that they want them to play, and then those doctors just play the song. They just say, you're not heard. So it's a bunch of, but yeah, I mean, every person has to have one, to answer your question, unless the case settles before it, because usually the IME is done after the deposition. So, after your deposition, then they'll schedule the IME. It's called an IME, DME, Defense Medical Exam. I call it DME, but they call it IME. But yeah, so if your case settles, after your deposition, it could settle. If the case settles, then you don't need to do it. But yeah, usually they do have, it's a step in the process. Okay, Lost in Awareness says, I'm okay with the 400,000 less, but I feel like when we go to mediation, they already know what I'm willing to take and won't go over that. So now I'm stuck with taking less or going to court and no in between. Well, I mean, you're not stuck. I mean, like that's why I like to negotiate from a position of strength, right? Just like evaluate the case, tell them what it's worth, like $1 million, $2 million, whatever it is, and just say, look, this is what I want, and if you don't pay me, then it's going to go up. It could go up. You don't have to stay low. You just, that's why I don't like to negotiate that entire way. It's just a different way of thinking. It's like a different way of framing the same thing. It's almost like a different language, But they don't like it, the insurance companies. Every time I do it, they either, change lawyers or pay me the amount or very close to the amount that I put in the letter, or, something happens. It just basically blows their mind. They get so upset. They start calling, the partners start calling, the adjusters start calling, but it works. I mean, every time I've done it, it's, caused some chaos. So it works. And other lawyers have done it. That's how I learned it, from other lawyers. Like I did that video about the $26 million settlement for I think that was in South Carolina, that $26 million case. That case, the lawyer, when it first started, the demand on that case was 800 something thousand. They were going to take 800,000 and settle the case, because they looked at jury verdicts, and there was another case with similar, it was a burn injury. There were another case with similar burn injuries that settled for 800,000. And then later it went up to like, 5 million, then later it went up to 10 million. But it's because the insurance company didn't, pay. If they paid the 800,000, the million, the 2 million, the 5 million, the 10 million, it would have settled for those numbers, but they didn't. So it just kept going up until I got to 26. And then they were like, okay, pay the 26, or we're going to try. I'm going to ask for 50. And at that point they were like, they paid the 26. So it definitely works. But I mean, it was a serious burn injury for a child. It was a serious injury. Okay. And then Shania says it's 3 months after my deposition. Yeah, I mean, after the deposition is an important time, because you want to make sure that, See, after you do your deposition, your lawyer then has to depose the other side, right? The defendants. And once he or she deposes the defendants, then as long as you have all the paperwork, meaning the document discovery done, you can file what's known as the note of issue. And then the case goes on the trial calendar. And once it's on the trial calendar, that's your wait. And then you get a trial date, and then you could settle the case. So that's a good place to be in. That's, you know, that's like the home stretch. It's going to be over soon. Okay, and then Vic says, Mr. Awesome, Frekhtman, my previous lawyer asked for 4 million, but that was before he found out that there was a 25 million umbrella policy. Could the case go higher if we go to trial? Could it go higher? Yeah, of course. I mean, like, you know, a previous lawyer that's now not handling the case, whatever they ask for doesn't matter, right? Because they're not handling the case anymore. Like, for example, if lawyer A is handling a case and lawyer A says, I would like, you know, 500,000, let's say. And then the insurance company says, oh, 500,000, that's so high. I'll give you 100,000. But then the lawyer gets fired. The client says, you know what? I don't like that lawyer. I'm going to fire him. I got a new lawyer, lawyer B. Lawyer B comes into the case and they say, oh, you know, lawyer A asked for 500. We offered him 100. Lawyer B says, 500? Are you kidding me? I want 10 million. Well, now, you know, that's what it is now, right? It's 10 million. Like if it's the same law firm, then you're going to have a lot of trouble, right? Because if you have one lawyer in the same law firm saying like 500,000, the other lawyer is saying 10 million, they're going to laugh at you. They're going to say, hey, these guys are a bunch of clowns because you're in the same law firm. You have to communicate with each other. But if there are two different law firms, you fired the first one, you have the second one, lawyer B, you could ask for anything. You're not bound by what some other guy did. That you don't know who that guy is. And, you know, he got fired. Maybe he got fired for a reason, you know? So yeah, you could ask for more, of course. There's no, you know, you just ask for what it's worth. And then Derek says, workers' compensation, I'm back. How much can you guesstimate a case with an L4-S1 disc ablation, L4-S1 spinal fusion, and a left ankle ligament reconstruction with the possibility of piriformis removal? Oh, that's really serious. Oh yeah, Derek, I think we were going to do a call together, right? Yeah, text me. Let's chat. I don't know, like I've said before, like I don't do the workers' comp. You know what I mean? I do the workers' comp, but I do the third-party lawsuits. So in the third-party lawsuits, I handle those. And then the workers' comp, I kind of have partners that do the workers' comp. In New York, the workers' comp, it's limited to lost wages, medical bills paid, and then sometimes you could do what's known as a Section 32 settlement to pay for your, you know, to get you like a lump sum. And if you get the lump sum, then you stop getting those payments that you would get every 2 weeks or those periodic payments. They stop and you get the lump sum. But I don't know how it works. It works differently in every state, so I don't want to tell you some misinformation. But I know generally workers' comp is less than personal injury. Like personal injury is usually much more, you know, much more. You get bigger verdicts for personal injury, smaller verdicts for workers' comp. I mean, smaller settlements, smaller lump sum settlements for workers' comp. Okay, and then Richard says, yup, 5.5, still waiting to see what it's worth. Their IME doctor even said I can't do my job anymore due to how physical it is. That should be good. Oh yeah, I mean, if their IME doctor said you can't do it, you know, that's good. That's very good. That's good for you because usually the IME doctors, like I said before, they always say nobody's hurt and they say a bunch of nonsense. So if they said you can't do it, that means it really must be bad. They can't come up with an excuse. Okay. And then Lost in Awareness says, ironically, I'm in South Carolina too. Oh, okay. Very cool. Very cool. Yeah. Yeah. That case was in South Carolina. It was, yeah, it was interesting case. I mean, it was, I think one of the reasons that case settled for so much was, I mean, the injury was really bad. I mean, the kid was like in the hospital for 7 days in the ICU and burns. But the other part of it was that, the bad conduct, right? Because the guy they had, the safety guy for the pool, he would just, you know, he was supposed to check the chlorine levels and they were supposed to be like no more than like, I think 7, but they were actually at a 10. So they were dangerous. They were, you know, basically harming the public. And he kept these logs, but the logs weren't accurate. And he had to admit it that he would just put that it was a 7 without actually doing the test. He was just like, I don't know, lazy. And then nobody else really checked. And then when they deposed the head guy, the guy who was supposed to be this guy's like supervisor, the head guy says, they asked him, well, how do you feel about that? That this guy, your safety guy, just puts 7, which is normal, and doesn't even check the pool, whereas it's dangerous. It could be burning people. And he goes, I don't really care about that. And I was like, oh, what? And so it was almost like very, very good for that they got these callous people, because then you could show that to a jury and say, look, these guys don't even care. Now you could ask for punitive damages because they're harming people, knowing that it's dangerous. So I think that's one of the reasons that was such a big case. Okay, and then Jetwing says, hi, Arkady. Hi, how are you? And Miss Chopra says, that's why I asked if I have to do an IME, because it's 3 months later. Well, no, I mean, the IME, they'll tell you. I mean, the lawyer should tell you. The way the IME is, it gets scheduled. The way it works is like, first, the insurance company and the defense lawyer have to choose a doctor. And they might choose more than one, right? Depending on your injuries. That could be an orthopedic IME, neurological IME, whatever specialty is involved in your case. Then they're going to send that to your lawyer. And they're going to say, Dr. Smith has scheduled an IME with you on whatever date. And they're going to give you time. They're going to say, if like May 23rd. And then your lawyer has to tell you, and then you show up. It's fairly simple. You'll know about it. So it's just fairly simple. Okay, Willie Stembridge says, good afternoon, everyone. Hello, my friend. Hi, how are you? Great to see you. Thank you for being here. Yeah, Willie's a really nice guy. I talked to him. Actually, that's somebody who texted me, and we had a conversation. We chatted. Yeah, absolutely. Thank you for being here. That's awesome. Yeah, feel free to reach out if you need any help. I'm always willing to, help as many people as I can. Just text me, 347-566-9595. And then Steven says they should make a movie about a lawyer with you playing in it. Oh, thank you. Thank you. That's awesome. Yeah, we should do that. And then Jetwing says, if you have an established consequential injury on workers' comp and have a third-party lawsuit as well, is the new injury added on both? Broken femur and both knees replaced. It could be, yeah. I mean, basically, you have to plead the injury for the third-party lawsuit. I mean, at least in New York, the way it works is you have to put it in the bill of particulars, which is a list of all your injuries. Now, you could supplement, right? Because you might not know. In the beginning, you might have a list that's short, but then later, like a few months or even a year later, you're still getting medical care. And now all of a sudden, you might say, you know what, I have this other injury, like something additional. So you just supplement it. But you have to add it. I think most states are like that, although bill of particulars is kind of an antiquated thing from like the 1800s, but they do have that here in New York. Some states might not have that. But yeah, I mean, sometimes workers' comp findings can be what's known as res judicata in the personal injury lawsuit, which means that if you already had a finding of law by the workers' comp judge, it's res judicata, so it applies in the personal injury case too, because it's already been litigated and there's already been a judicial determination. But I don't think like an injury like that gets res judicata, right? Because you could have the injury in workers' comp, but then in the third party case, the jurors might think it's not caused by, it's not caused by it. So there's a lot of different factors. There's a lot of different factors. Okay. And here's a question from Junior. Can the public go observe any personal injury trials in New York City to get an idea how a trial goes? Yeah, absolutely. Trials are public, so you can just show up, and of course, yeah, absolutely. And then Mike Jordan Groupie says the thumbnails are getting serious. Massive respect to Arkady. Oh, thank you so much. Yeah, we try to mix them up. I actually asked my video guy. He's actually on vacation now, but I think he's like a work vacation. He's down in the Dominican Republic. He's doing some work, but he's also on vacation there. And so I got a little tired of it. I'm like, these thumbnails are always the same for the lives. It was like the picture of me, I think, with a thumbs up, and it has the FAQ. I said, let's do something new. And he said, okay. And then he got me this John Wick. I was like, whoa, that's pretty cool. And I just wanted something new. I thought maybe like get your answers, because it's not about me, right? It's about you guys. It's about people getting answers to their questions. It's about you getting an answer to your question. So that's what it's all about. Okay. And then Laura says, if they set my reserve in my case at 5 million, is that important in my settlement? Yeah, that could be important. I mean, like basically the reserve it's internal. It's what the insurance company sets. because that's what the insurance company believes they have to keep in reserve, right, to pay for your settlement or to pay for your verdict. So that's what they set aside, meaning like they don't think it's going to be more than 5 million. So they have that money set aside. That's their reserve. So yeah, that's important. That's good to have. If it's 5 million, that's good. That means they're taking it seriously. Okay, and then Wayne Sellers says, what will settle first, my claim or the heartburn following ACDF? Oh yeah, I know ACDF is really serious. I was just talking to a gentleman now, somebody also a YouTube viewer, and he had just had ACDF. He's still in the hospital, and he wanted a consultation. So I was talking with him. I was surprised. He's speaking really, really well, because one of the things with ACDF is sometimes you can't speak if you just had the surgery, but he was speaking really well. I could understand like every word. So he said he's feeling well too. That's good. He's going to have a good recovery. Okay, and then James Jordan says, I mean, he's attorney Frekhtman podcast is providing enormous psychological relief because people who are injured and trying to get justice have nowhere to turn. Thank you, Arkady Frekhtman. Oh, thank you so much. Thank you, Mr. Jordan. That's really great to hear. Yeah, we try to help. That's basically what we try to do is just help people, help injury victims and families. That's what it's all about. Okay, and then Jamarian Carter says, if the video of my accident went viral and the video is being used as a training video for truck drivers all over America, can I get compensated for that on its own besides my case? Oh my God. I don't know. That's actually an interesting question. Maybe, yeah, right? Because it's your accident. I don't know if you can get compensated for that. But yeah, I mean, feel free to text me about that. I'm happy to chat with you about that. Maybe take a look at the video. Um, you know, but that's good for your personal injury case if it's such a egregious violation that they're using it as training for other people. Then yeah, that's really good for your personal injury case. It means you have a good case. And Leonardo says, if a big case is better, lawyers sent a watchdog, I think. Oh yeah, for the IMEs, yeah, you send a watchdog, because a watchdog basically just means an observer. So the observer is there with the doctor in that defense medical exam, and then the doctor will say, oh, I did this test, like straight leg raising, and it was normal. But the watchdog will actually write down, he lifted the leg, he only lifted it like 30 degrees, he didn't try. And then, or range of motion. Like, for example, they'll say, oh, I tested the range of motion of the neck, like flexion, extension, all the different ranges of motion. And it was normal. And I used the goniometer, which is like a machine to make sure. But sometimes they don't use the machine. They just say they used it in the report. So the watchdog will say what they actually did, because the watchdog is actually there observing. And the reason you need that is because in many states like New York, you're not allowed to have a video recording of the IME. If you're allowed to have a video recording, I would record it. That way you could just have it. That's even better. But yeah, the watchdogs are good. They document every single thing that happens. Okay, and then Talk says, what would 3 bulging discs in the neck and back along with a fractured elbow, non-surgical tear in the left elbow, contusion on both knees, and possibly 3 fractured rib tips from a car accident be worth? Oh, wow, that's pretty serious. I mean, it depends. I'd like to know like what the policy is, where it is, what city it's in, but that could be worth a lot. I mean, a fractured elbow with all those bulges, and then you have a tear, even without surgery, but that doesn't mean you won't need it ever, right? You might need the surgery down the road, like as you get older, 5 years, 10 years. I mean, that sounds like it could definitely be worth anywhere from $500,000 to over $1 million, but I would, just text me 347-566-9595. Okay, and then Miss H. Chambers says, I had a labrum shoulder surgery with 2 anchors placed in my shoulder, was dealing with pain months later after surgery, and got a new MRI with contrast that revealed he drilled a 3rd hole in my shoulder. Bone by error with no anchor. So have an empty drilled hole in my shoulder. He didn't put that mistake on the surgery report. And why did he do that? Now I need a revision surgery with a new surgeon. Is this grounds for a malpractice lawsuit? I mean, it could be. With malpractice, what you have to do is you have to get all the medical records and then have a medical malpractice attorney review the medical records. And then you have to show 2 things. Number one, you have to show that the doctor made a mistake. which is a deviation from good and accepted medical practice, right? Because there's like the lowest common denominator, that's like good and accepted medical practice. Now, if the doctor deviates from it, right? He's here. That means he can't even do the basic thing that all doctors have to do. So that's number one, basically that he was negligent. And number two, you have to show that that negligence caused your injury. So if he drilled a hole, if that hole is then turning into some kind of permanent injury or giving you some kind of problem, then yeah, that's definitely that sounds like a pretty strong case. Okay, and then Mike Jordan says we appreciate you. Oh, thank you so much. And I appreciate all of you guys too for watching and for listening and for reaching out to me. It's great because people are, reaching out, and I'm able to. I gotta come up with a new system though, because it's like I can't call everybody back always because I get a little busy, but I want to. I want to help. It's just like I get a little busy with paperwork, and now I have a trial coming in the Bronx on April 15th, so I have to prepare for that. So but I want to still. I'm doing my best. Like today, I think I called 4 or 5 people. I may have to call a few more later today, so I'll do my best. But I was thinking about using one of those calendar links, like Calendly. I think it's called Calendly, and then it's like people just click the link, and then you choose an available spot, and that way it's a booked appointment. People that need consultations, and that way we'll have a time. But some people just say anytime. Then I call it goes to voicemail, and then we have to go, and then it's hard to keep following up. But yeah, I want to help as many people as I can. Okay, and then James Jordan says thank you. So thank you so much. Yeah, absolutely, absolutely. Yeah, so let me know if anybody else has any questions. I think we're almost at the 40-minute mark. Oh, it's after 5 p.m. It's like 5:15 here in New York, Eastern Standard Time. Let me see if anybody else has any questions. If not, I guess that's pretty good. We got about 40 minutes of the live. And then we could do a few more. I'll do a few other topics. I have a few other videos that I've already recorded that are in the kind of like, I guess, in the queue. And I want to maybe start doing some other stuff, maybe some shorts. Because, I think most of the shorts on the channel are from the long video. So basically, like, there's a long video, like let's say a 20-minute video, and then we just take like 30 seconds of it and we turn that into a short. But I want to actually do some specific content just for shorts, because I feel like sometimes, you could say something in a short, and then that could maybe be on other platforms, right? It could be here on YouTube. It could be on all those other platforms like Facebook, Instagram, even TikTok, right? For the younger people, and that way we could get a little bit more um, more people and get that message out there. So I'm going to work on that. I'm going to work on maybe some shorts as well. And by the way, if anyone has any topics that you want to see for a video, just let me know. Like somebody said they wanted the ulnar nerve injury. I think 2 people said that, and then I did that, and that premiered I think this week. So yeah, I'm happy to do that. I could do topics like videos for and the other thing is that now I have access to more. I think I said this before, but I have access to more databases. So that's a good thing, because with access to these databases, I could then go to like any state, and I could do a little bit of research about what's happening in that state, the cases, the verdicts, settlements, by case. Like for example, slip and fall, or ceiling collapse, or car crash, truck, types of injuries like fusion or traumatic brain injury, whatever it is, burn injury, whatever it is, open reduction, internal fixation. And then, you get a lot of information there. Sometimes some of these databases, they actually have a lot of information. So you'll see, I think I did a video on lumbar fusions that might be coming next week. And then I think I did one more on construction. And I'll make sure to do a few more. Okay, let's see. We have a few more comments. Oh, Suzette says hello. Hi, how are you? Great to see you. Thank you for being here. That's awesome. And Joaquin Fonz says, wife slipped and fell in Disney World, broken elbow with internal fixation surgery, screws and plate inserted. It was raining outdoors, but the platform she fell on had a roof. Do we have a good case? I mean, the injury is really serious. That's serious. Broken elbow with internal fixation. If the platform had a roof, then it shouldn't be wet inside. It just depends on how big the roof was and all the circumstances. I probably have to take a look at the photos, or but it could definitely be a case. I mean, obviously, if it's indoors, there shouldn't be rain indoors. So that obviously would be a good case if it's indoors. Like I had a case similar to that, the case I talked about before, where a lady was trying to pick up her kid and it was indoors, but it was the staircase. So it was maybe like 5, 6 steps from the door. And then once you go out the door, now you're outdoors and it's raining all day. It was a really bad rainy day that day. And this is a school. So then they have like just the concrete, and they have like a basketball courts where they go out for gym and recess. So anyway, so she's walking down, she slips because there's a puddle because people are tracking in and out. But they had all these like policies that they're supposed to look, they're supposed to clean, they're supposed to put non-slip matting, and they didn't do any of that. So that's what was the basis for the liability, and we got 1.4 million on that. So it's possible to win those, but I would say, yeah, it's possible to win those, absolutely. But I would just depend on all the facts and circumstances. But yeah, feel free to text me 347-566-9595. Okay, and then Lost in Awareness says, are you able to see what's been done so far in a specific case through those databases? Well, yeah, I mean, no, that's a little different. See, a specific case, what you do is you look it up. Like, for example, in New York, you could look it up through the New York State civil electronic filing. So that'll tell you everything that's been filed, the electronic filing. It's a federal case, you could look on Pacer and you can get all the federal documents. There's also something known as e-law in New York. And, most states have that. I think in Florida, you could look it up publicly. In California, you could look it up publicly, and you could see what's happening with a case that way. But these databases are more like cases that have already been done, either settled or taken a verdict, and then they have a little write-up about what happened, the lawyer, the expert, all the negotiation, like what they asked for, what they gave. And so yeah, so that those are two. I mean, they're just two separate things, but yeah, you could definitely look up cases that are active too. Okay, and then H Chambers says, one more question. What does it mean when your lawyer says he's going to start litigation on a personal injury case? Does that mean he doesn't care to ask the policy limits for a settlement? I mean, no, I mean, start litigation just means file the summons and complaint. And so, yeah, I mean, it means that he could have tried to get a settlement, right? And then the settlement just wasn't enough. But it just means the case is going to start. He's going to file a lawsuit, which is a good thing, because usually when you file the lawsuit, that's when they tell you what the policy limits are, the primary policy, as well as the umbrella or the excess policy. And that's what you want to know. And you could always still settle a case after you file a lawsuit. In fact, what they do is the insurance companies usually have a claims adjuster. And see, the way insurance companies work is they have layers. So the claims adjuster might only have authority up to a small amount, like 25,000 or 50,000. But then once you file a lawsuit, you get a litigation adjuster. Now the litigation adjuster might have authority to 100 or even 200. And then the next layer is the next person. And then once you get over 1 million, it's the next person. You see what I'm saying? So it's good to file a lawsuit because then you can access those additional layers and get more money on the case. And Suzette says, I watch the shorts as well. Oh, awesome. Thank you so much. And Amazing says, insurance claims pre-existing, but there is nothing for my medical record that says so. How to fight this? No record of herniated discs, just a checkup from 2016 for my sore back. I'm a bus driver. By accident, head-on collision with an SUV. Okay. So yeah, I mean, the short answer is you don't really have to fight it because remember, if they're saying that your accident is pre-existing, then that's an affirmative defense, right? Or that your injury is pre-existing. That's an affirmative defense. That's something they have to prove. And if they have no evidence, then, I would just call it a frivolous defense because, you have to prove that you got hurt and that your injury is caused by trauma, meaning caused by the head-on collision. And so your doctors will testify to that. They'll say, look, this person was healthy before. They just had one appointment in 2016 for a checkup. They're healthy. But now that they had this head-on collision, they have all these injuries, right? And this is caused by the head-on collision. And they'll give you the medical reasons why. So then that's prima facie. You've proven your case. And, they can't just say, no, it's pre-existing, right? They have to have a doctor talk about why it's pre-existing have like prior medical records, have prior MRIs showing that you already had this injury. So if they can't show any of that, then you just call it what it is, which is a frivolous defense. Just like, some people have frivolous lawsuits, like, I cut my little finger and I'm suing for $1 million. Well, that's a frivolous defense because you're saying that the person was hurt from living their life, that it was already pre-existing, but you have no evidence of that. So just call them out. I think a jury would get mad at them for doing that because it's like they don't want to put a value on somebody's pain and suffering, which is what the law says, right? You have to put a reasonable value on all the pain and suffering and all the injuries and the impairment to your life. They don't want to do that. They just want to come up with a frivolous, make up defense. So I would definitely call that out. Yeah. And then Ms. Chopra says, as an attorney, are you surprised that so many people with lawyers still need help? Yeah, I mean, I don't know. I think I am somewhat surprised. I mean, some people like they complain that the lawyers just don't call them back, so they can't get to communicate. Like what one gentleman was telling me, look, I can speak to the paralegal, but I can't speak to the lawyer. So that's not good because you really should be able to speak to your lawyer. I mean, after all, you hired a lawyer, you should be able to speak to your lawyer, get a consultation. If the lawyer is your guide and they're guiding you through this litigation process, which is like kind of like a dark woods, you have to go through those deep, dark woods, and they know how to get through the woods. But then if they don't call you back, they're like abandoning you by yourself in the woods. That's not good, right? What kind of person does that? That's not good at all. So yeah, so I think, and the other thing is with attorneys is that, like, I did a video I think last week, and it was about that whole scam that they do with the medical and legal, and it's almost like a spider's web, and they catch people in there, and then people don't know. Well, why should they know? They're just injury victims, right? They got hurt in a car accident. Why should they know? But there's these spider webs, and then basically you go to a chiropractor. The chiropractor says, you got to go to my lawyer. This is the lawyer. The lawyer even comes to the chiropractor's office and signs people. Then they get signed. Meanwhile, the lawyer, the law firm, is paying the chiropractor for that referral. They're paying, let's say, $2,000 back to the chiropractor. But then the lawyer now has to pay $2,000 to get your case. These are like law factories. They don't go to court. That's why, in that example of my client, they were telling him 50,000, but the case is he has a $500,000 policy with excess, with like another 2 million excess. Probably we don't know yet, but we'll find out soon. But at least 500, and he's already had surgery, and he needs another surgery. Why would you say it's worth 50 or 80 or 100? It's worth the full 500. If you go to court, if you work up the case properly. But they don't ever do that because they get a lot of volume from these physical therapy offices. So the whole thing is like a big spider's web. You get caught in there like a mafia scam, whatever you want to call it, but it's terrible. And then, what the other thing that happens is then the doctor, will say, look, do you want a narrative report? Now, narrative reports from physical therapy offices, they're free, right? You just get them. There's a high-tech law. So for $4, you can get it as a federal law, or they could charge you a few cents a page. But what they do is they say, no, I'm going to write up a narrative report, and they charge the lawyer like $1,000, and now the lawyer gives them $1,000. That's just the way of the lawyer paying them for the case, but he's calling it a narrative report, right? It's like a trick. And then the lawyer will also charge for personal injury protection, no fault. Charge the client. Meanwhile, it should be free. No fault is just the law. It's statutory. It's the law in New York. You get $50,000 in personal injury protection. See, and then they'll send you to a funding company, and the funding company will give you, let's say, 10,000 with no cap, meaning the 10,000 can turn into 100,000 or 200,000. Meanwhile, there's other companies that 10, but the 10 will be capped at 20. You'll never be more than 20. So why would you want your 10 to become 100 and owe 100 when you can just owe 20, right? It's just like mind-boggling. So they're doing this whole thing, but you got to be careful with that. People get sucked into that. I just don't want people to get. I don't want injury victims to get screwed over with that stuff. Okay. So that's one of the things. But then somebody else was saying, actually, it's funny today when I did my consultations with people, two people said the same thing. They both said, we have to advocate for people that cannot advocate for themselves. And I thought that was so true. That's such a true statement, right? You have to advocate for people who can't advocate for themselves. Because if you get injured, you have like a traumatic brain injury or whatever it is, You can't advocate for yourself. You're not a lawyer. So that's like my job. I want to advocate for people who cannot advocate for themselves. And that's what two people said it today. It was actually funny. It was like back-to-back consults I did. I think one person was in like Western Pennsylvania, maybe near Ohio. He said it. And then I called another lady, and she said the same thing in New York. So two people said the same thing, and I thought that's so true. Okay, I guess we'll have to call it soon. Let me go through these questions, and then we'll call it for this episode. But we'll do more. Don't worry. Okay, what tactics do you use to get the defense attorney to cooperate throughout the lawsuit process? I mean, just get the court orders, the court, use the court. If they don't give you what you need, just file a motion, compel, strike their answer, and that's the best way to do it. And then James says, Attorney Frekhtman is a nice guy. He may not know that there's a lot of bad attorneys out there who mislead their clients and try to move them through their office like cattle. Appreciate the podcast. Oh, thank you so much. Yeah, that's the thing I hate, when they just kind of catch you in that spider's web, and then I mean, okay, like if you have a small case, right, like a little fender bender, it doesn't really hurt you that much. They'll get you 5,000, 10,000. Maybe they're good, for that purpose. But when you have a serious case like this guy had, like 2 surgeries, and it's a $500,000 policy with excess, the guy could be looking at like a $2 million case. You don't want him shortchanged for like 80 or 100K, and then also all these like fees that you shouldn't be paying. It's just not right. And then H. Chambers says, I'm on my 3rd surgery for a third-party case while injured at work, shoulder and back. Can you settle a personal injury claim before a workers' comp case reaches maximum medical improvement? If so, how does that work with subrogation? Can you settle a third-party claim? I think it depends on which state. It depends on the workers' comp law. Usually, I think from what I've seen, you can, but it might be better to settle the workers' comp first, because then, or wait a minute, if you settle the personal injury first, then you might not have a workers' comp lien to pay back. So that could be beneficial that way. I'm not sure, honestly. I would ask that to like a workers' comp specialist, because like I said, I don't really do too much workers' comp. I usually just kind of get a workers' comp lawyer to handle the workers' comp, and I just do the third party. So I'm not too familiar with like the subrogation and all that stuff, how they do it. But I think you can do it both ways. Okay, and then Amazing says, thank you for all your help. The best lawyer ever. Okay, thank you so much. Okay, have a good night, everyone. Talk to you soon. And please like and subscribe to our channel. Leave us a comment. We are here for you. Our goal is helping serious injury victims and families. Okay, all the best. Bye-bye.